Okay, good morning, everyone. Welcome. Let's call to order this hearing of the Assessment Appeals Board for October 5th, 2015. And we'll start with a roll call, please.
Board Member Crow.
Present.
Board Member Curtis.
Present.
Board Member Stern.
Present. Okay, great. Next, we'll stand for the Pledge of Allegiance, and if you do intend to provide testimony, please remain standing, and we'll take care of our oath after that. Ready to begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Great, and so if you do intend to provide testimony, please remain standing.
You do solemnly affirm that the testimony you're about to give in the matter now pending before this board will be the truth, the whole truth, and nothing but the truth?
Great, thank you. And we'll go right into our agenda. And for those who haven't been with us before, we'll go through each agenda item to determine its status and come back with any hearings that will move forward today. So we'll start with items 6 through 19. And the applicant's name, Brusco Tug and Barge, Inc. And with the clerk's permission, I won't read all of the
Yes, that's
application
fine.
numbers.
This item is request for approval of a large value stipulation agreement, which has been provided to the board by email. The board
Great.
is free to ask any questions or ask the assessor to give an overview if they'd like.
Okay, I believe we've all received the stipulation ahead of time via email. Are there any questions or discussion from the board?
No.
Okay, so looking for a motion to approve.
So moved.
I will second that motion.
If you could please put this into your computer terminal.
I'm sorry.
Can do that. Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries. I'll wait, Brendan, I'll wait for you to tell me when you're ready to keep going.
All right. We're ready for the next
Okay. Next, item 20, application 13-10777. Applicant is Green Energy Holdings LLC, and this is for approval of findings of fact that's continued from August 3rd. Morning, Ms. Porsche.
Good morning, Chairman. I believe the findings of fact have been circulated and the clerk can fill in the board. I believe everyone has approved them.
Yes, board member, all the 3 board members have approved by email. The only board member that isn't here that heard the case is board member Little, who emailed for approval.
Okay, so no action required at this time, or would you like a formal?
The clerk would request a motion for approval.
Okay. So looking for a motion to approve. One of the 3 of us was not included in that hearing, is that right?
I believe, yes, board member Curtis was not present at that hearing.
Okay. So we'll probably, Mr. Crow, if you don't mind making the motion.
Motion to approve the findings of fact by the county counsel's office.
Okay, and I will second the motion. Mr. Curtis, I assume you'll probably abstain, unless you didn't get a copy of it, right?
I believe I didn't.
It depends, how would you like us
It
to?
doesn't make a difference.
Okay.
All of you can vote yes to approve the motion.
Okay. Okay, so then we'll back up, and all those in favor, let's just vote affirmatively. I think that was.
Aye.
Okay, and I as well, and so motion passes unanimously. Next, item 21, application 14-10689. Applicant is Zed Audio Corporation. And it looks like we have a stipulation.
Yes, let me pass that out. This is a stipulation submitted for approval today. The application is for a 2014 decline in value assessment, and the stipulation There's a question as to policy or jurisdiction, I guess. The Board of Supervisors resolution is to exempt all personal property under $10,000 and under from taxation. Generally, this is done in a stipulation by stipulating to zero with the statement that the market value is, something under $10,000. This one was submitted at $10,000. So it is the clerk of the board's opinion that the board needs to order the stipulation to zero instead of $10,000. But we're not sure how to proceed because the situation hasn't arisen before.
Mr. Chairman, I believe it'd be appropriate to hear from the assessor.
I agree. Morning, Mr. Meyer.
Good morning. Kent Meyer, Ventura County Assessor's Office. We're just going to request that we withdraw that stipulation and continue it pending a corrected stipulation.
Okay. And Mr. Vlahakis from the clerk's office, is that?
So if the
Sound right?
board determines, so we have this is scheduled for hearing tomorrow with the hearing officer. So what we did is we also put it on the hearing officer agenda for tomorrow. Should the board not approve the stipulation today, then, or take action on the stipulation today, then it would remain on the hearing officer's agenda for tomorrow, and then it can be continued at that point. So if the board wishes to take no action on the stipulation as presented, then no action is required, and we'll take care of the continuance tomorrow at the hearing officer meeting.
Okay. Are there any questions or comments from the board?
No, I think we should abide by the assessor's recommendation. Withdraw it and then present it again tomorrow.
Okay.
I agree.
Okay, so then we're looking for, I believe, just a motion to continue pending stipulation unless you need two. Do we need two actions or one that first withdraws? Or,
I would recommend that it's, no, I don't know. We don't need to continue pending stipulation because the hearing isn't until tomorrow, so that's the hearing officer is going to do.
Okay.
If the board had approved today, it would have canceled tomorrow's hearing.
so maybe since it hasn't been executed yet, there's no action that we,
Right, that's my
Roger.
thing, is the board just
Take-
needs to take no action on this item.
okay. Great, we can do that.
Okay.
Does the applicant know to come tomorrow also?
I have not called them yet. This came up, this came up Thursday, and then council was researching it Friday, and we just didn't get time to get all the ducks in a line. So we, I don't know. I'll let the applicant know they have the option to come tomorrow. I'm not exactly sure. Haven't got that far of how to handle tomorrow's hearing.
Okay. Thanks. Let's go then next to items 22 and 23. Applications 14-10815 and 14-10816. Applicant is Boeing North American. And let's see, we have, this is continued, and we'll wait to hear the status.
Good morning, members of the board. Joe Vinatieri on behalf of the Boeing Company.
Morning.
What we'd like to, we talked to Mr. Meyer beforehand and are going to be talking with him afterward also. Some information was provided to him several weeks ago, and I think it's appropriate to take a site tour. This, as you probably know, is a rather controversial property, and there are several issues that go with it that make it a difficult and complex valuation subject, so we need some more time on this.
Okay, and so a continuance is probably in order. Mr. Meyer, any comments from the assessor?
We agree that we should have a continuance. We believe that it's a complex property, but we also think that we can resolve all issues without board intervention. I'd like to recommend continuing till March 28th.
This time, the clerk is only recommending continuances to January 11th. Once the 2015 calendar starts, we're going to try to keep that 2016 calendar starts, we're going to try to keep that as restricted as possible. And this case specifically was already given an extra amount of continuance, as continued from March, and at that time, they asked for a longer than a normal extension. So at this time, the clerk would prefer only continuing cases to January 11th, 2016.
Mr. Meyer, how do you feel about that?
That'd be fine.
And that's acceptable going.
Okay, great. And did you say, I'm sorry, was it January 15th, Mr. Philhakis?
January 11th, 2015
Got it.
is the first 2016 meeting of Assessment Appeals Board number 1.
So January 11th, 2016.
Right.
Okay.
Okay, so just to make sure, January 11th, agreeable to both parties? Okay.
Yes.
Okay, great. Are there any comments or questions from the board?
This is the Rocketine site.
It is one and the same.
Great, so we're looking for a motion to continue to January 11th.
So moved.
Second?
Okay, moved by Mr. Crow, seconded by Mr. Curtis, and motion carries.
Thank you, members of the board.
Thank you.
Board members, would you please vote on your computer terminals?
I'm sorry. Okay.
All right.
Ready? Okay. Next, item 24, application 14-10965. Applicant is Howling Nurseries, Oxnard.
This is another request for approval of a large value reduction stipulation agreement. This was provided to the board. The board is free to ask any questions or ask the assessor for an overview if they prefer.
Okay, we all received the stipulation via email ahead of the hearing. Are there any questions or comments?
I have none.
Okay, so looking for a motion to approve.
So moved.
Second?
Okay, moved by Mr. Crow, seconded by Mr. Curtis, and motion carries. Okay, next item, 25, application 14-10998. Applicant is Julie Zimmerman.
Yes, this applicant called me Friday. Their child is having some severe medical issues. I asked her to submit a document, so let me pass that out to the board real quick.
Okay.
Thank you. So due to the circumstances, the clerk is recommending the board issue a continuance to January 11th, 2016.
Okay, any questions, comments from the board?
No.
Okay, looking for a motion to continue to January 11th.
So moved.
Second?
Moved by Mr. Crow, seconded by Mr. Curtis. Motion carries. Next, item 26, application 14-12204. Applicant is John Zaki, and looks like this is continuing again with a stipulation for a large stipulation. Is this one that we had received? Thank you.
I do
Beforehand?
not believe, I
I
can't
don't
remember
think
if
so
this is
either.
when I sent you or not, I sent so many documents. This, I don't believe you received this.
Okay.
This was originally continued pending stipulation from August 3rd, 2015, and the assessor's office has submitted a request to cancel the board's preliminary approval of the stipulation. I'll let Mr. Meyer explain that a little further.
Okay.
We had, of course, as Mr. Velakis had said, stipulated to a value with Mr. Zaki. Upon review of the original stipulation, once it came into our office, realized that this stipulation was actually invalid. There were two applications filed on this specific parcel, two different sales, and the board had ruled on the first sale back in January. I think we stipulated that one also. And when we did this new stipulation, we were using the values and the supplemental line numbers from that first sale, not from the second sale, which is what this application deals with. Upon further review, we feel that a stipulation may not be in order at all for this parcel. So the original stipulation is invalid, and the second, and we now believe that this application has some issues with it also.
Okay, and so what action is being requested?
Right, so, and I'll just show you, in the board's packets, we provided the 2014 application with the attached supplemental and the proposed stipulation that is now being requested the board vacate. And then there's also the 2013 application with its supplemental and a stipulation that was approved by the board on that. And so just so that you have confirming, the stipulation in 2013 is for the same line item number, parcel, dates, and value that this 2014 was. So we were able to confirm that the clerical issues with the stipulation that the assessor was talking about. So we would, I don't know what this is another one of those weird ones where we haven't had before. The board needs to take action to, we need to, let's see, I'd say vacate the preliminary approval of the stipulation and direct the clerk to schedule this matter for a valuation hearing at a future date. And so the clerk will then schedule this for a valuation hearing.
Okay. I just had a quick question in relation to the applicant. Is the applicant informed or agrees with what we're
The clerk
discussing?
emailed the applicant and notified them that this would be discussed today and that they could be present here if they wanted. They didn't, they were aware, they emailed me back and they didn't seem like they were interested in coming today, but they understood that if the board rescinded approval, that evaluation hearing would be scheduled.
Okay. Mr. Meyer, any comments on that in relation to the applicant? Okay. Any questions from the board?
Any comment from council?
Mr. Velakis provided notice to the applicant that this would be coming up on today's agenda for proposed vacation of the stipulation. I believe that satisfies the due process rights of the applicant, and the board can decide to do whatever it deems appropriate in its discretion.
Okay.
So the purchase price of $356,400 was not accepted by the assessor?
That is correct. The two transfers were approximately 7 months apart, and the purchase price for both transfers were the same value, and the assessor did not accept either one of them. Now, we stipulated with the first one because they did provide us information regarding condition at the time of the first transfer. We believe those condition issues may have been resolved prior to the second transfer.
I see.
Okay. And let's see. So we're looking for a motion, unless there are any other questions, to vacate the preliminary agreement to stipulation, the board's prior action, and then from there, scheduled hearing for valuation. Is that correct, Mr. Vlahakis?
Correct.
Okay. So looking for first, unless there are any questions, a motion to vacate the board's prior action to approve the stipulation.
So moved.
I will second that motion.
Okay, moved by Mr. Curtis and seconded by Mr. Crowe, and the motion carries. And in terms of the rescheduling, is that just something that the clerk's office will take care of?
Yeah, I'll take care of that. That's fine.
Okay. Great. We'll go next to items 27 and 28, applications 13-11128 and 14-10870. Applicant is Shaheen Azurmer,
Thank you.
and looks like we're continued. Thank you.
Yes, this is a subpoena evidentiary hearing continued from April 20th, 2015. The applicant is required to provide the summons evidence at this time.
Thank you.
Thank you.
Okay, and before we move forward with anything, I just want to clarify with our clerk that this, there's no hearing scheduled for today, only
This is the only hearing
determination?
scheduled, yes.
Okay, so the first action is to determine whether the information that was summoned was provided, and then,
Right, the
To
board
proceed.
is required to find if the applicant met their burden of production.
okay. And is our applicant here?
If you'll please come forward to the
Come on
podium,
forward.
or you can take a seat up here if you'd like.
Good morning.
Morning, members of the board.
Could you
Sean
please
Hazelton.
push the button on the base of your microphone, and then the light should come on? Great.
Light will come on.
Yep. Okay.
Good morning.
So if we could start and just, if you could state your name for the record, and then we'll get a little info, an overview from the assessor, and then we'll proceed from there.
Sean Azarmer.
Okay. Good morning, welcome back.
Thank you.
And Mr. Minor, could you provide just a little bit of info so we can get as much as we can before we proceed?
Back in April 2015, we had requested information from the applicant, and a subpoena was issued by the board. We had a process server make approximately 5 or 6 attempts to serve the applicant. We have a copy of it for the board members and for county council. They were unable to deliver and serve the applicant. We also sent it via United States Postal Service, and they were not able to get a signature from the applicant. And we also sent it via UPS, and have not had any response from the applicant whatsoever.
Okay, and let's see, the subpoena required information that had not already been supplied, and
Correct.
has that information been received by the assessor at this point?
It has not been received.
Okay. And do we have a copy of the subpoena or the information that's specifically in
It
question?
should be at the back of the packet with the application on it. So the application includes all of the board's minute orders, and the last document should be the last document issued, which is the subpoena.
Okay, and just before we move forward, just administratively, Mr. Meyer, is the assessor prepared to move forward with the information that is received already today?
We are not prepared to move forward today.
Okay.
So what I believe the process, and we can confirm with council, for when a subpoena is issued, the board needs to, I guess, allow the applicant to present their case, and then determine if the subpoena requirements have been met or not. If not, then the board would deny the case for burden of production. If the applicant meets the summons evidence requirement, then the board would move forward with the assessor's presentation.
Okay. Before we hear from the applicant, are there any questions so far from the board for anyone? Okay. So why don't we hear from the applicant in terms of the subpoena and the information requested and the status?
Okay.
Please.
Well, I just became aware that I guess if I don't meet my production requirement under the subpoena, my case gets dismissed.
There's a possibility
Right?
that could happen.
I wasn't aware of that.
Okay.
I was prepared to move forward with my case today, and that was my understanding of it. When it was originally scheduled, that's what was on schedule. It wasn't just a hearing for the subpoena. So that has changed. So I wasn't on notice of that change.
Well, I think if we take first the issue of the subpoenaed evidence, and then we can go forward from there in terms of the status of moving forward today with the hearing. That's the way we would normally work.
On its face, it seems like they were unable to serve me. I can see why, because I have been out of town continuously since this date. In fact, I came to town for this hearing. I can see that they were unable to reach me. They could have emailed me or called me, but no one did any of that. They went to my office and were unable to serve me. I was physically not, for parts of it out of the country, for parts of it out of town, but I can see why they were unable to serve me. So if they were unable to serve me, how is it that they can, that the procedure can set aside my case? It doesn't sound fair.
Okay, well, go ahead.
I think there's two issues here. One, whether there was compliant service of the subpoena, and two, if there was and there isn't a subpoena production today, what are the consequences for Mr. Azarmir? With respect to the first issue, whether or not there was service of the subpoena, it's clear that from the paperwork provided that there was not personal service of the subpoena. There was a May 20th exchange of information where apparently Mr. Azarmir said he would pick up the subpoena at the assessor's office when he returned from being out of town. Have you done that, Mr. Azarmir?
I wasn't back from out of town. My business was delayed, and my first obligation is to my wife and family. I need to support my wife and family, and I need to work. So even though I'm very respectful of this procedure, and I made sure that I came back for this procedure, I have to work, and if I have to work, my work is out of town, I have to go where my work is.
Mr. Chairman, there are also testimony from Mr. Meyer that there were alternate attempts at service of the subpoena, that there was an attempt to give written notice by U.S. mail and an attempt to give written notice by UPS. With respect to civil court proceedings, if someone is a party, the Rules of Civil Procedure provide in Section 1987 that a party, you're not obliged to personally serve a subpoena on a party, you can give written notice. So it is my opinion that the mail service would be legally sufficient. However, if the consequences for Mr. Azarmir's case is that the board would provide evidence preclusion sanction where the board would, since he hasn't provided what the assessor has requested, that the board would not be inclined to hear his case in chief. I think that for purposes of an appeal, we would be better postured if, since Mr. Azarmir, do you have the subpoena now, Mr. Azarmir?
I do have the subpoena now,
Okay,
yes.
okay. I think it would be better postured if the board continued the hearing to a date certain in the future, with Mr. Azarmir clearly served with the subpoena, Mr. Azarmir produced the documents, and then we don't need to get to the issue of a catastrophic consequence for Mr. Azarmir's case. That's if the board chooses to follow that advice.
Okay.
The clerk would just note for the record that we also, along with the minute order, mailed a copy of the subpoena, and the applicant was provided a copy in person at the April 20th, 2015 hearing, and I believe we made it pretty clear that the evidence would have to be provided, and it was discussed with the applicant present in person. So it's the clerk's opinion that there should be no continuance and that the board should require the applicant to provide the summons evidence today. That's
Okay, thank you.
the clerk's office.
Okay, let's go to any questions or comments from the board, if there are any at this point, to either the applicant or the assessor before we move forward. Go ahead.
I would like to raise objections to the subpoena. Since this is an opportunity to have you evaluate the subpoena itself.
Okay, thank you. Do we have any questions right now from the board? Comments?
Are you prepared to present the evidence that the assessor wanted?
I do have a case to present, and as part of my case, I would produce documents, but I'm not responding to the subpoena issue because I guess it is your decision now to continue it to a later date. But I would like to object to the elements of the subpoena.
Okay, understood.
By way of example, I mean, on this tax record request, I have a tax return privilege that would prohibit you from requesting these documents. My understanding is that the probative value of requesting these documents is only to determine whether I used that address on my tax returns. And I can just tell you, I think that the request itself is punitive. It's a technique that the assessor is using to put me in a difficult situation, asking for things that they're not really entitled to and are private to me. The assessor well knows that there was construction going on at that location, that the building was red tagged. Nobody lived there during this entire tax period. So the law says that the owner must be in possession, not that they have to be living there. I couldn't have lived there. The place was under construction. So just
Okay.
even the
Before we get-
requirement of this is not accurate, is not in good faith.
Okay, thank you. Before we get to the details of the case, we need to tackle first the issues contained with the subpoena. So in terms of the tax returns required in the subpoena, it sounds like you're stating that you're not willing to produce those, is that correct?
I have a legal tax return privilege that I'm invoking, so I
Okay.
don't want to.
Okay,
I have a
understand.
right. I'm asking for you to recognize that right, and then if I don't produce it, is my case going to get thrown out? I mean, that sounds not proper.
Okay.
And also, the request itself is not proper. I don't think that the assessor has a right to ask for people to produce their tax records. Tax records are privileged to each individual and protected.
How
Okay.
about the comparable sales or the comparable market rent?
I have all those, and in fact, many of those comps that we're using are ones that the assessor has produced. So those are all within their records already.
So you have them, but you didn't supply them to the assessor, is that what you're saying?
I just, I actually have them with me, but I just arrived on Friday back in town. So,
Okay, thank you.
I mean, I was thinking that if I bring it to the hearing, that would be sufficient. As part of my presentation, I would be producing the documents that are relevant to this.
But still, you knew on April 20th that you needed to supply the comparable sales and the comparable market rent to the assessor, correct? Or no?
Well, I don't want to say anything that would work against me here, okay?
Okay.
You have a subpoena, the subpoena was not properly served. They could have, I guess if they wanted to use the procedure, they could have published it.
Okay.
But, and I was out of town, so there's no way that they could have served me. They should have served me properly. So if this is, it depends on which position you're going to take. I respectfully want to, protect my rights here. I don't know if I can convince you to change the subpoena. But, I thought that if this is a hearing, you should consider my privilege and rule on the privilege, whether I have this privilege or don't have this privilege, because the law says I have this privilege.
Okay.
Mr. Chairman?
Thank you. Before we go any further, and I'll make sure we get to you, Mr. Meyer. The subpoena, I was looking for the original date of the subpoena. Ms. Porsche, could you help me with,
There is a date next to Vince Curtis's signature, which appears to be April 20th of 2015.
okay. There are two reasons why I was asking. Number one, just to verify that. And I'll get to number two in a second, but obviously, when the subpoena was issued, it was determined that the items requested were within the scope of the Assessment Appeals Board's authority to require. Is that correct?
Yes.
Okay, great. I know that since then, there's been some discussion of what the board will allow to be included in a subpoena in terms of items 3 and 4, that we might not today include comparable market data or things that are publicly available in a subpoena, but this is already executed.
It's council's opinion that any objections that needed to be asserted on the date that the subpoena was originally presented to the board for
Right.
action. And the board made a determination that it was relevant to seek focused portions of the IRS tax returns, not the entirety of the returns and not necessary parts of the returns. And the board granted the request for
Right.
The comparable sales data and the comparable market rent data. The applicant has made a record of his objection here today. It was appropriate for him to make a record, but in council's opinion, he's seeking 2 bites at the apple. And the board is not obliged to grant him 2 bites at the apple unless the board wishes to do so.
Okay. And so we'll come right back to you in a moment. I'll make sure we do. And so our actions are probably limited to either we have options of continuing
Yes.
or denying the application because of the lack of production at this time. Is that correct?
Yes, and I did opine previously that I did believe the applicant was adequately served, not
Okay.
the optimal personal service, but that the written notice was sufficient.
Okay. Thank you. So let's go back to Mr. Meyer. You wanted to make a comment, and then we'll hear from the applicant again, and then we'll make a decision or ask more questions.
I just wanted to point out on the process servers, on the second page, May 20th, 2015, toward the middle, they did contact Mr. Asmer, let him know that there was a subpoena issued, they were trying to serve it on him, he said he would come pick it up. So,
Okay.
bottom line is, there were lots of attempts to serve Mr. Asmer.
Okay, thank you. And we'll just take a break again. Are there any questions right now from the board? Okay. Go
Also,
ahead.
my tax return is filed jointly with my wife. My wife also has rights. I hold this property as my separate property. My wife is not on title on this property, but now they're demanding tax returns that have her financial information and privileged information on there. I think she has rights. I think she has objections. I'm conveying those objections in addition to, again, the demand. If the assessor wants to prove the address that was used during that time, where we were living during that time, the tax assessor knows well that nobody was living there. In fact, there's a stipulation as to construction that your board approved on this property that shows that there was nobody living there. So the concept here that they're trying to verify an address by demanding tax returns is improper.
Okay, thank you. Quick question. If we continue the hearing to a future date, are you willing to provide the items in the subpoena? Sounds like the answer is no, but I want to clarify.
The answer is yes.
Oh, good.
I will comply if I have to, but
Okay.
I'm requesting that your request is improper. And
Understood.
I'd like to have an opportunity to appeal that concept. Again, I disagree that when the subpoena was issued, I had no time, no opportunity to appeal it or to object to it. I made some objections, but there was no, I think you should serve me with the subpoena first, then I should have an opportunity to appeal to the production requirement of that subpoena, then I should have, then, once that's determined whether I need to produce it or not, then I have to produce it. So this is the first time that, I still have not had an opportunity to appeal the appropriateness of requesting tax returns as part of a property tax evaluation. But I assure you, I would comply if it comes down to it. I have, that's just the person I am.
Okay,
And Mr.
thank you.
Chairman, we feel that if he wants to appeal the subpoena itself, he should go to a higher court for that.
Understood. Thank you. Okay, any discussion or questions from the board? Let's hear from our counsel.
Mr. Chairman, there would be personal identifiers such as potentially a social security number for Mr. Azumir's wife. If the board doesn't believe they need to have that level of detail on the pages, then the board can indicate that it's appropriate to redact that information so that at least the wife's private, confidential, personal identifier is not revealed in this process.
So are you suggesting that all we need is a document that says what the address was? Is that what you're?
The subpoena speaks for itself. Those portions of the tax return that would either show the rental, reported income for the property under appeal, and applicant's physical residence, those portions.
Well, tax returns don't show an applicant's physical residence necessarily. I have used my office address for tax purposes for the past 20-something years. I have never used the residence. So,
So to the assessor, could you refresh our memory what portions of the tax returns you're inquisitive about?
There is disagreement as to burden of, who had the burden of proof in this case. He was claiming that it was owner-occupied residence and that only family members lived there at the time.
Okay, so now he's saying no one has
Now he's
lived there.
saying nobody lived there, but within everybody's tax returns, you can put down a mailing address for your tax returns, but you're also required to put in a physical address.
yeah, it's my office. I've always used my office.
So the physical address is what you're seeking?
Your actual, where you actually habitate.
I don't think the tax return requires you to put.
Let's understand your comments.
So where were you living at that time?
I was, because the property was red tagged and we couldn't live there, and we were in the process of bringing the property into compliance with the requirements of the city of Santa Paula so that it could be occupied. We were kind of displaced. We were living my family is fortunately well-to-do. I was living on a family estate.
Okay,
And I really don't want to discuss this because it's kind of embarrassing to me.
Understand.
I mean, this is, that they're really getting into things that, the reason we're going through all this is because I have had a personality issue with the assessor's office. And every one of my properties is scrutinized, and the amount of money that's being charged is unreasonable. They should assess my property. They shouldn't assess me. They may like me, they may not like me, they may like, my background or religion or whatever it is. But it shouldn't be that they can subpoena my tax records or do things, that are not proper.
All right, so noted. Thank you.
okay, so let's just go, Mr. Meyer, in terms of the tax returns, the applicant has stipulated that he was not residing in the subject property. Does that satisfy the question about burden of proof for the hearing?
Not completely, because we also wanted to get his reported income for that property. Now, his appeals were for 2013 and for 2014. He's claiming it was red tagged. It was never red tagged. It was under construction. They did a conversion from retail to residential on a 4-unit property. And that was completed in December of 2012.
Okay.
This is the red tag notice that was on my door during that time. They red tagged the property. No one was supposed to even go inside that property.
And what's the
Okay.
date on that?
red tag date on the notice, 12/11/2008. So I was unable to enter that property other than for construction for that time period.
Okay,
And this was also a difficult situation that we went through to resolve the matter.
okay, I think we have enough information to deliberate and take some action, so, again, to the board, we're now just having a discussion with the three of us. We have options that include continuing pending information submitted by the applicant. Suppose we could modify the terms of the subpoena, or it could be denied completely today due to lack of production related to the subpoena. I would be okay with, if we do think it's going to help the process with continuing pending the applicant supplying more information. Interested to hear what you all think.
I think the applicant is basically refused to provide the information, and I would make a motion to deny his.
Okay, so I want to make sure that we have it on record. Mr. Crow did make a motion before we, go ahead.
I said, before the board takes any action, I believe the taxpayer did say he had comparable sales evidence, so the board might be required to review that and see if it sufficiently meets the subpoena requirements. I'm not sure, because he did indicate he might have a portion of what's required.
Okay.
And so I'm not sure how that
Thank you.
affects the board's ability to take action.
Got it, thanks.
In the position of the board would be strengthened by permitting the applicant to put on whatever portions of the case the applicant has, response to the subpoena, and considering that before the board votes on any kind of terminating sanction. I think you're just in a stronger position as a board if a reviewing court looks at it.
Okay. So, Mr. Crow had commented that he believes that there's a motion on the floor to deny the application due to lack of production. And so, first we'll ask if there's a second to that motion.
May I?
Not right now, but we'll come back to you for comment.
So I tend to believe that the applicant's stonewalling the process here, and I would go with Mr. Crow, though I would think in all fairness that I would agree with our counsel and have the applicant put on his case and see how much of the subpoena information that he has supplied.
Okay.
You know, still considering that it sounds like the assessor isn't ready to move ahead anyway, so.
Right, so it sounds like the assessor does not have a case prepared, is that correct?
We actually do have a case prepared, but we were expecting this to be a subpoena hearing.
A subpoena hearing and a regular hearing are one and the same. There's no pre-hearing discovery through subpoena. If one looks at the property tax rules, the subpoenas are not for pre-hearing discovery, they're for discovery at the hearing. I'll read you the rule. I'm looking at Property Tax Rule 322, and I'm looking at subsection E, and I'm reading a portion of that. Subpoenas shall be restricted to compelling the appearance of a person or the production of things at the hearing and shall not be utilized for purposes of pre-hearing discovery.
So, Ms. Portia, if it's at the hearing, then my assumption that I can bring the material to the hearing and use it at the hearing is not improper.
Yes, but when the assessor has subpoenaed it, the assessor's entitled to have it provided to the assessor to review, before the commencement of the hearing.
Before the hearing.
So if you can provide that to the assessor, that would be very helpful.
Okay. I
Would you
think-
like me to start producing some, the subpoena information then? Because I have all the stuff. I have, let me look at the subpoena. I have the
Do you have the tax returns that were subpoenaed?
tax return, I'm going to invoke the tax return privilege, but on, I
Okay,
have all
I'm
the
going
rest of
to, I'll stop you for 1 second. Okay, so what, just for the board, what, I'm sure that the process we'll go through is if we continue, the assessor will ask, my guess is, and is able to ask, entitled to ask and receive at least a continuance or a denial due to lack of production with the subpoena, since the tax returns have not been supplied and nor is there an intention to do so today. So I think if we just continue with the hearing, we can do that. However, it's inevitably not going to be concluded today. I might be more inclined to continue, since the applicant testified that he's willing to supply the tax returns, and rather than go through the process of not having that supplied unless I'm missing something.
Sure. How does the assessor feel about a continuance?
We feel that this should be denied due to burden of production.
Okay, thank you. Okay, so let's make a decision on whether or not to continue. I believe there was a motion from Mr. Crowe to deny right now. I didn't hear a second, so I'll just confirm that there was not a second from Mr. Curtis. I was not willing to second it at this point.
I want to hear any further comment from council.
I believe if a reviewing court were to look at the board's action, that the board's position would be strengthened on appeal if it considered and reviewed what Mr. Azarmir did bring here today, and then reviewing that information, the board decides, because there's partial noncompliance with subpoena, to deny the application. At least it's done it with full information.
Okay.
And to Mr. Crowe, what was your motion again?
Well, basically, since the applicant, as I'm reading the amended stipulation, amended subpoena there, it looks like basically they're just asking for the income and expenses of that specific property, and the applicant has refused to provide that information, and therefore, and it sounds like he does not want to provide it. I think he's has not met the burden of production.
So again, you haven't supplied what's been subpoenaed to you as to the assessor, correct?
I'm sorry, I have a response to this subpoena prepared for today.
Okay,
If you
we're
feel
not
my
looking for
response is
that.
defective
No,
in
we're
any
not-
way,
we're
are you
not.
going to deny my, well, I'd like a tentative ruling. Are you inclined, because I kind of feel that one member wants to deny my hearing.
Okay, I'm going to stop us for 1 second. I think it's clear that the applicant does not have the subpoenaed.
Okay.
He's already testified that he doesn't have the
So
tax
I'll
returns.
go ahead and vote with Mr. Crowe.
Okay.
I have,
So we
I would
have-
like to respond to the subpoena, so that it's on the record what my response was. I have.
I think we already
Full
have-
response to, you have 4 elements to the subpoena.
We have
We have, I think we have,
public testimony.
we do have a lot of testimony from you, I think, regarding the information. So we
But I
do,
have all the information.
well, we've, before we move forward, you've testified that you do not have 2 of the 4 elements that were required in the subpoena. And
I'm
so
testifying that
we're-
on those 2 items, I'm taking my
Understood.
tax return privilege.
Okay,
But on the other ones, I have them. And in fact, there is
Okay.
a approval by the appeals board that shows what the stipulated value of the property is. So I'd like to share that approval that you approved, or this board approved.
okay. Understood. Thank you. We have a motion and a second to deny the appeal due to lack of production. And so let's vote on that. Mr. Crowe and Mr. Curtis already voted on that. I will vote against it. The motion is approved by a majority, and so we're finished.
Thank you, Mr. Chairman. For the completeness of the record, since Mr. Azumir has offered what he called his response to the subpoena, I think we should, I would ask the board if the board would consider accepting that as an exhibit, just so the record's complete. He says he has something called a response to the subpoena
Okay.
that we introduce it as an exhibit today.
But
Okay.
the motion has passed. My case is now no longer. Is that correct? My case is dead.
Yes, the board denied your application.
What
If
is
you
the-
wish
what-
to introduce as a record.
What is the appeal of this process?
May I ask the clerk, were findings requested?
That's what findings of fact were requested on the application. I'm verifying if they were paid for or not. I do not believe they were paid for yet. It didn't cross my mind to check this ahead of time. I apologize. Yeah, findings of fact were requested on the application but not paid for. So the clerk would need to receive a payment of $150 right now if the applicant wishes to request findings of fact, which are necessary to appeal the board's decision to Superior Court.
And how long do I have to appeal?
Huh?
How long do I have to appeal?
You first have to file, this is designated as a claim for refund, so you have 6 months to file in Superior Court.
Thank you.
Mr. Azumir, the clerk was telling you you need to pay for the findings
Yes,
in order
I
to
will,
preserve your right to appeal.
Go to the clerk's desk as I leave this seat. Thank you.
So I will, the rules are if the clerk doesn't receive payment or the clerk receives payment and it doesn't go through the bank, and that's what just happened in some cases, then findings of fact don't get issued. So for now, we'll assume findings of fact are going to get paid for. If they do not, the findings of fact just won't be issued. So the board, should the board continue approval of finding of fact, council?
We can set a date 45 days out on the contingency that the clerk receives a negotiated check that passes and clears.
I have how much is it, $150?
$150.
I do have $150
Okay.
cash with me now, and I can present that, so this is no longer an issue.
Okay. Thank you. We'll go next, well, we'll take a minute to take care of the payment for the findings. Mr. Vlahakis, if you could help with that, appreciate it.
If the chairman likes, the remaining items should only take 30 seconds, so, oh, never mind. All right, I'll
It's okay.
mail your receipt by the end of today. Thank you.
Okay, thank you. Okay, we'll go next to item 29, application 1410347. Applicant is Ashley Construction, Inc., and this is,
This is an item, Mr. Chairman, that I had taken some more time to do research on, and I'm prepared to brief the board if the board would like to meet in closed session on research
Okay.
items.
Right, the clerk just put this on the agenda because, mostly for us to keep track of it, because we do have to issue a written notice of the board's decision by the end of tomorrow, but the board can discuss this item and make their decision in closed session, so no action is necessary by the board at this, on the hearing at this time. Action is required by the board from closed session before the end of the day tomorrow.
so I believe that means we would have to take care of
Come
it
to a
right now.
decision.
Okay.
Yes.
Why don't we we'll go into recess for,
The board, it's already been taken under the submission, so the board doesn't have to come back on the record and announce it. So I would recommend the board go through the remaining 3 agenda items,
That's fine.
And then close the hearing and do their deliberations in closed session, and then we can close
Okay.
down the hearing.
Okay, thank you. Okay, so then we'll come back to item 29, after the adjournment. Items 30,
So the clear
30 and 31.
Yes, for items 30 and 31, and as well as item 32, I didn't do this very well, I apologize. It's the first time we put this on the agenda, it's the first time's agenda. The findings of fact were from hearings that occurred before the break period, and they had to be issued within 45 days of the hearing. So while the board was dark, the hearings were approved by the board members by email, and then sent with a cover letter to the applicants. And so, because these hadn't been put on a public agenda, the clerk wanted to put them on today's agenda so it could be publicly acknowledged that findings of fact were issued in a timely manner on these two applications. So we're just asking that the board make a motion to receive and file the findings of fact for items 30, 31, and 32.
Okay, thank you. So hearing that, we're looking for a motion, unless there are any questions from the board, to approve the findings of fact for items 30, 31, and 32.
So moved.
Second.
Okay, moved by Mr. Crowe, seconded by Mr. Curtis, and motion carries. And last, we have our stipulations, items 34 through 78 on the agenda. I believe we've all received them ahead of time, and so I'll ask if there are any questions or comments.
Yeah, I was wondering on item 52 and 53, there was Air Center helicopters, the value was reduced to 0, and I just wonder if that implies that those helicopters were not in the county at that time. There's not.
Mr. Meyer stepped out of the room, but I believe there's a statement to that on the stipulation.
Really, those steps don't show much as far as information. I don't think,
I believe.
on the personal property steps, it looks like that information's not there.
Yeah, you said Air Center helicopters, correct?
Correct.
So there is a statement hidden in there that says, "The purpose of the stipulation is to cancel the 2014 assessment," which both stipulations have in them. So I don't know if that,
Yeah, it just.
okay, I
just
guess
says
that doesn't answer the question, though, is why
Doesn't
the
answer the
assessment was
question.
canceled.
Needs to be a form on those personal property steps.
I saw Rick
Applies what it's all
Denham go
about.
out the room, I think, to chase Mr. Meyer down.
Yeah,
So let's just wait for a second, see if,
yeah.
Just a second, I have to get Arnold, he knows me.
okay.
Yeah, it's kind of a shortage on that personal property items. It doesn't really say why any of those were
Right,
being
and
reduced.
the board can request that the assessor put additional detail when they're canceling assessments if the board thinks that would be
I think it would
helpful.
help understanding a little bit of what's going on sometimes.
Especially if it goes to 0.
On the real property one, it has a little box on there, that facts of information.
You called Mr. Greenberg? I did. All right.
The lady in the back there, part of the. She lady back there.
She works with me. Tomorrow.
You.
All right.
Hi, Mr. Greenberg, if you could just state your name, even though we already know you, and we had a question regarding a stipulation.
Arnold Greenberg with the Ventura County Assessor's Office. I'll answer whatever questions you have.
Great, thank you. Mr. Crowe, go ahead.
On Air Center's helicopters, were those helicopters out of the area on lien date?
I have so many appeals that I'm working, I want to make sure I can answer.
The value was reduced to 0, so I assume that's.
The value had been reduced to 0, and the statement in the stipulation said the purpose is to cancel the 2014 assessment. So Mr. Crowe would like to clarify why the 2014 assessment was being canceled. I can provide that for review if you need.
You know, I don't remember exactly. I mean, there are any number of possibilities. I wish you'd Should I go back to my desk and look it up? Because I think I know the answer, but I'm not sure at the moment.
We could do that, or we could continue, we could take this out of the stipulations and continue it
I can just
for
go back
approval.
to my desk, and, I mean, it'd take me 2 seconds.
Okay,
You know, the board
Great.
has some deliberations to do, so we could take a recess and come
Let's
back
do
with
that.
an answer?
Yeah,
Okay.
because I can answer the question.
Okay.
I'll be right back.
So we'll
Thank
take
you.
a short recess, and I'll just call the board out when Mr. Greenberg has returned, so.
Okay,
No
so-
major rush, Mr. Greenberg, they have some deliberations to do, but.
So we'll be
not all
in,
day either.
we'll be in recess for,
Board ready to go back to record?
yep.
And we're back on the record.
Okay, we're back in session. Thank you again, Mr. Greenberg, for being here. And we had a question regarding a stipulation, items 52 and 53 on the agenda. Mr. Crowe, if you want to go ahead and, do you remember what the question was, Mr.
Yeah, yes.
Greenberg? Okay, go ahead.
Absolutely. Arnold Greenberg, Ventura County Assessor's Office. This was a situs issue. The applicant had provided, finally had provided evidence to show that both helicopters had been permanently removed from California prior to the 2014 lien date, and that was sufficient for cancellation purposes. They never responded to our request for a 2014 aircraft property statement. They didn't otherwise provide any useful information, but that was the reason for the cancellation in both
Got it.
cases.
Okay, thank you.
Thank you.
Yes, sir.
It'd be, on those little personal property stips, could there be a little paragraph added in there, maybe a little remarks about why?
You know,
They can be-
of course, and actually, I typically do that. I think you've noticed that I provide comments at the bottom where appropriate. I didn't do that in this case, and I should have. So I'll make sure I do it from now on.
Thank you.
My pleasure.
Great. So are there any other questions related to the stipulations, items 34 through 78?
I have none.
Okay, so looking for a motion to approve.
So moved.
I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crowe, and motion carries. And next, we'll go to public comments. And any,
Look, not really too much public comment. I would just say that I guess I may have not made it very clear. The Assessment Appeals Board hearing for October 19th has been canceled. So the next meeting of the Assessment Appeals Board will be November 2nd, 2015, and the following will be December 7th, 2015. And that will be the only remaining hearings for the year. And there'll be an Assessment Appeals Hearing Officer meeting tomorrow on October 6th.
Mr. Vlahakis, since you brought it up on November 2nd, I don't show myself scheduled for that date, but maybe I just don't have it in my
I
calendar.
think we're in this transition period of getting things set up to have two boards. November 2nd has board members Curtis, Sis, and Little.
Okay.
So that is correct. Neither
Okay.
of those two board members are. So we'll next see board member Stern on December 7th.
All right.
Ashley Construction?
Oh.
That's not required to be announced on the record, so.
Is there any action needed on this?
No other actions on the record are required.
I guess not. Okay, and any board comment? Okay, so we are adjourned at 10:51.
Right.